that these going to be individual items, investigator, or do we need to do these collectively?
No, we are going to be handling these in three parts. And so the first one will be agenda item number 48 regarding Mateo Paola.
Okay,
Hold on a moment.
Oh.
I believe we were gonna do item 52.
Oh,
Okay, that's fine.
which one first?
We're gonna do item 52 and then we'll come back to these.
Okay, so a changing what I said earlier, colleagues, we will actually start with item 52 on your executive session agenda. If you want the page number, you can find that for yourself, but it is page 222. So we'll proceed to consider item 52 involving Mr. Mark Simonson. When the staff tells me we're ready to go, is he appearing? Mr. Simonson is on the phone, as I understand it. Is he on the phone yet?
I just entered him into the room. He is with us.
Mr. Simonson, are you, can you hear me?
Yes, I can.
Thank you very much. Let me tell you, just to provide a quick summary of how we're going to proceed today on this item involving you. Thank you for being on the phone with us. We're going to proceed through a 5-part process here. I'll summarize that briefly.
Okay.
The first will be a presentation by our investigator on your issue. The second will be a time for us as commissioners to ask our investigator questions. Thirdly, we'll reserve time for you to make any comments you choose to make on the record to us. And if you do so choose, which is your prerogative, please introduce yourself for the record at the proper time. Next, number 4, we'll ask you, we will have the opportunity to ask you questions based on what you say to us. And then lastly, it'll be a time for the commission to discuss and make a decision on the issue before us. So that said, I will turn to our investigator, who I believe is Finstermaker, investigator Finstermaker. That's Pacheco, I think, is it not? Andrew? Investigator McIntyre, is this your item?
Absolutely.
Please proceed. Thank
All of
you.
them. You'll hit the right one.
It takes me a while, but I have Investigator McIntyre listed right here for this one. So I'm now in sync with Investigator McIntyre's report. Please deliver it.
Thank you, Chair Fiscom. Andrew McIntyre for the record, and thank you, Commission, as well. This is agenda item number 52 related to Mark Simonson. Mr. Simonson is alleged to, or he's a board member for the Clatsop County School District, also known as the Warrenton-Hammond School District. Mr. Simonson is alleged to have used his official position as a board member of the school district to financially benefit his daughter, a Miss Mindy Little, who is an employee of the same school district. It appears, based on the information that was gathered, that Mr. Simonson was initially faced with a potential conflict of interest at a December 13, 2023 board meeting, and that was related to his daughter filing the complaint against the school district, related to a lot of different things. One of the complaints was that she was getting paid unequally, not getting paid fairly. It does appear at that particular meeting, Mr. Simonson did declare a conflict of interest. And at that time, because it was a potential conflict of interest, Mr. Simonson was permitted, and it does appear that he participated in the discussion and voted on the matter. Mr. Simonson, during the course of the PR, admitted that was the only time that he made a conflict of interest disclosure related to this matter. Later on February 7th, 2024, the board discussed and voted on dismissing Ms. Little's complaint. Once again, it does not appear that Mr. Simonson declared a conflict of interest at this time. It appears he voted on the matter, and that matter could have a financial impact on his daughter or a relative, Ms. Little. Thus, it appears that he did use his official position to financially benefit his daughter. Later on July 24th and August 1st, it appears that Mr. Simonson may have used his official email address to gather information in order to aid his daughter assertion that she was not being paid fairly by the district. It also appears that on August 6th and August 10th of 2024, Mr. Simonson used his official position to potentially influence the board's course of action related to a new complaint filed by Ms. Little against the superintendent and school district. And that complaint was going to be discussed at the August 14th meeting. Once again, at that August 14th meeting, it does not appear that Mr. Simonson declared a conflict of interest. Further, he participated in the discussion related to his daughter's complaint, including making specific comments related to that could have a financial impact on his daughter potentially. Therefore, there appears to be a substantial objective basis to believe that Mark Simonson may have violated the prohibited use of office and the conflict of interest statutes, and the commission should move to investigate.
Investigator, for your report, appreciate it. Colleagues, any questions for our investigator that come to your mind? Hearing and seeing none, we'll turn to you, Mr. Simonson. This is your chance to make any comments you choose to make to us. Thank you for joining us today by phone. At the moment, we can hear you, I believe, but please, this is your chance. Identify yourself for the record and please proceed.
Okay, thank you for allowing me to present today. My name is Mark Simonson, excuse me, and I've been on the Warren-Hammond School District Board of Directors for approximately a year and a half. I'd like to present some facts to the commission prior to addressing Mr. McIntyre's findings. Nearly all documents before the commission are identified as either confidential and/or attorney-client privileged. As I'm sure the commission is aware, many safeguards are in place to see that these types of documents are not released without multiple layers of authorization in place. None of the materials released and before the OGEC commission today have that authorization. A minimum of at least 3 policies authored by the Oregon School Board Association and approved by Wharton-Hammond School District have been violated, namely policy BDC, titled Executive Sessions, policy BDD, titled Board Meeting Procedures, and policy BBF, titled Board Member Standards of Conduct. Oregon Revised Statutes 332.061 sub 2, nearly in its entirety has been violated as it relates to the release of a minor student's name, the issue, and a discussion therein. Also related to this ORS, many of the same documents violated federal law titled Family Educational Rights and Privacy Act, enacted in 1974. This document as well has been investigated under Title IX Civil Rights Enactment in 1972. As required by the OGEC's own procedures as posted online, it states that before any complaint can be elevated to the level of the commission, it must first be released to the lower level for review. As of November 26, as documented with the Wharton-Hammond School District Board of Directors Vice Chair, Tabitha McGordy, no complaint is on file with the district as received or on the docket for review by the Wharton-Hammond School District Board of Directors. Clear violation of OGEC's own protocol, and if true, upon review of this document, a false statement to the state agency if this is a requirement to move to this level. In closing, it's my opinion that a minimum violations stated in my opening statement show possible prohibited use of office by Wharton-Hammond School District Board Chairperson Neil Bond, as well as possible state and federal violations. So that's an opening statement. Thank you for allowing me to put that. I would like to go through a couple of these. The investigation, do you guys have this in front of you? The documents?
Yes, sir, we do.
Okay. In the documents, I don't know what the date of it is. It's the ones that we saw on February 7th, I believe, or 7th. Yeah, February 7th, page 12. First, I want to bring out a couple examples. I need you to see the background on why I voted the way I did. That's why I'm doing this. On page 12, it says the investigator confirmed that indeed 2 teachers. This has to do with a protest, and his findings are that there was no protest. So the investigator confirmed that there were indeed 2 teachers at Wharton Elementary who wore Team Rock shirts. And it says there was no evidence supporting that notion that there was any type of protest. Further down, it states Josh Thompson, who confirmed that Campbell and Gantenbein paid him to print the shirts. The 2 teachers were specific about the design. It is essential to highlight that Campbell shared the shirts that that shared that the shirts were commissioned to support Hyan, which was our principal. Mr. Hyan is not an opponent to, he did not want Warrior Academy. And they were in front of her space with these shirts on. And by definition, that is a protest to come out with shirts, at least a perceived protest. But yet he felt this was not a protest. I believe that's unwarranted and that there was a protest. Later on, towards the bottom of page 13, Ms. Little expressed concerns about the age discrepancy between Warrior Academy Center students and Warren grade school students. That's where the Warrior Academy was located at the time. He states whether Little's requests were dismissed or carefully considered as debatable. Well, so then he goes on and makes a determination based on opinion, even though he himself says it's debatable. On page, I grabbed a few of these, so I'm going to bounce a little bit.
Mr. Simonson, this is Chair Fiscom. Can you kind of move through what you have to say fairly quickly, because we have a tight schedule today, so please proceed, but do so expeditiously. Thank you.
I can tell you this to you later then, if it goes that way. In the end, what I want to say is that I believe that that the findings in all cases is very opinion-based, very subjective, and in the minutes, it even says these are the names of the different board directors. Alex noted his concerns. This is after we reviewed this investigation. Alex noted concern that there were assumptions made by the investigator. Mark expressed his opinion. These are verbatim. Mark expressed his opinion that a large portion of the investigation is suggestion and opinion, wanted facts. Darlene noted the focus of the investigation seemed to only focus on one part of the discrimination when there seemed to be many more. And I'll just read one more. Darlene thinks this is bias based on to the district. Why were people chosen, given to him for information regarding the complaint coming from the district? Aren't they usually given by the complainant? So with that said, the very last thing that happened there is this was a 101-page document. It was given to us at about 5 o'clock in the afternoon to be reviewed at 6 o'clock for a vote the very next day. It gave us no time to prepare, to read it, to actually go through what we needed to do. So at the very end of the communication, it said further discussion on whether the board should read through the report line by line tonight resulted in Mark, Alex, and Darlene wanting to, but the majority of the board wanted to move on. So we were forced into a majority to vote on this document. Not having enough information, not being able to review the document, that in his first statement, Mr. McIntyre's first statement, February 7th, participated in a discussion that therefore it appears Ms. Simon's attempt to use his position to financially benefit his relative. It has nothing to do with benefit a relative. It was the lack of information that we were provided with, allowed to review before we made a decision. So that has nothing, that the outcome, I guess, maybe would have been towards my daughter, but it has to do with the subjective nature and biased nature of the investigation and the lack of board chair to give us enough time to even review the complaints and the outcome of that. The 24th and 1st, he states using official officer request wage information. We had a meeting in June, and we hired 2 positions. It was for a high school principal and for a vice principal. We are currently in a deficit spending budget. This was an opportunity to save some money in the amount of roughly $300,000 to $400,000. Myself and a couple others were not in agreement that we should hire the principals. On the consent agenda, all it states is the name of the individual being hired and the position hired for. It does not give an amount, a contract, or anything like that. So that email that was sent the 24th of July and the 1st of August, the first one was request non-rep salaries so that I could see what our new principal and vice principal were being paid. They did not include that on the 24th, so I once again on August 5th requested specifically those two, and then it was given to me. I did not use that any further. I have it on file so that I know what the budget numbers are for those positions. So again, that was not, it wasn't used for anything. It never went past me asking for them so that I could see what the wage packages were. 24th.
Mr. Simonson, I'm going to have to call a quick end to this in a moment or two. Any final comments for us before we have a chance to ask any questions? Please proceed quickly.
Yes, the very last thing I sent to Mr. McIntyre, and I hope it went to you, the conflict of interest. I sent a thing to our council legal for the district explaining that I did not understand conflict of interest and I needed help with that. She was to consult me through that. She did tell me to declare a conflict of interest at the first and last, or at opening and in executive session. She never once counseled me further after that in these other meetings. I thought they were a continuation of the same thing because it is. She was in attendance at all these and did not tell me I needed to do it at those. And I know ignorance does not play a part. That's why I went to legal, because this is exactly what I did not want to happen. I needed her to consult me and tell me when I needed to do that, and that did not happen. And I guess
Okay, thank you, sir. Stay on the line and listen further. Colleagues, this is now the time to, if you choose to do so, to ask Mr. Simonson any questions based on what he said. I'm going to bridge that request to you for a moment and ask our investigator or our director for any comments that they might have to make in light, particularly of Mr. Simonson's early comments about documents being protected by attorney-client privilege, if I'm quoting him accurately.
I'll defer to see.
Please, Director, make any comments. And he also suggested that maybe under our rules, we have the obligation to sequester documents or make them private. So please proceed.
So we do have in the statutes that we can subpoena or request documents if they are otherwise confidential by law, and we obtain them by subpoena, they would remain confidential. So the bigger issue here, Mr. Simonson, is that a lot of what you're talking about relates to the district's internal investigation, and that is separate from what we are looking at. We have no authority to enforce the district's policies or the district's rules. What we are looking at is whether you participated in making decisions or used your position in a way that would or could potentially benefit your daughter. And that is all we are looking at. We are not looking at whether the district exceeded its authority, whether they took actions they weren't allowed to do. It is simply in these particular meetings and these actions, could they have benefited your daughter? And if so, did you make the appropriate disclosures?
Thank you, Director. Colleagues, now's the time to ask any questions of Mr. Simonson, if there are such questions, as well as if you have questions for our investigator or director, this would be a time to ask them. Please proceed, anybody. Hearing and seeing none for the moment. One last chance. Colleagues, any questions for Mr. Simonson or our executive? Please, executive, proceed.
The only other thing I would clarify to Mr. Simonson is that we're not making a decision on whether there's a violation We're simply making the recommendation that the case move to investigation where our investigator can work with you to find the appropriate answer.
Okay.
Thank you,
No,
Director.
Honestly, I will talk to him further because I think our board as a whole, I don't know if you guys provide educational sessions, but we are lost, me in particular.
Well,
I'm-
one of our major emphases as a commission is education. So I'm sure our staff will be in touch with you about the training that would be available for you and your colleagues. Thank you for mentioning that comment. Colleagues, now's the time for us to move toward a decision on this matter. I'm happy to take any comments about how you colleagues think we should proceed today. Mr. Thompson, please.
I think there's a lot going on here, and I think that the preliminary review raised some questions that an investigation could answer. So I would support moving this to investigation to answer those questions.
Thank you, Commissioner. My comment exactly, I would concur with what you just said. I think there is more to review here, and sometimes this next comment is one I make at the end of a decision. I'll make it now to underline what our executive has said. I want Mr. Simonson and everybody to understand that if we decide to move forward today, which we have not yet decided, but if we do decide that, we are not, emphasize not, finding that there has been an ethics law violation. We are simply deciding that we need more information. This is a distinction that's often not well understood. So I make this point with emphasis today, and I wanted to underline what our executive said a moment ago. That said, Commissioner, you ready for a decision? I'll turn to Commissioner Payne, please, if you're ready.
Yes, Chair. I hereby move that the commission find that there's a substantial objective basis for believing that Mark Simonson may have violated ORS 244.040 and ORS 244.120, and that the commission should investigate accordingly.
Thank you, Commissioner. Any comments on the motion, colleagues? Hearing and seeing none, the administrator will call the roll. Item 5.2.
Commissioner McCauley,
Aye.
Commissioner Burke,
Aye.
Commissioner Thompson,
Aye.
Commissioner Payne,
Aye.
Chair Fisca.
Aye.
Motion passed 5-0 with one abstention.
Thank you. Mr. Simonson, thank you for your patience with our agenda today and for being with us by phone today. We appreciate your comments. And our staff will be in touch with you directly about the next steps in this process as we both investigate as well as emphasize the option for education and training. So thank you for being with us today.
I appreciate all your guys and maybe the help that you can provide to me and the district, and look forward to further conversations. Thank you very much for your time.
Thank you.
Thanks, Mark.
Bye.
Colleagues, we'll now move back, starting with the proper item between item number 45 and item 50. And Investigator Fenstermaker or others can tell me how you'd like to proceed in the next moments on these matters once we have the proper people online. So please outline our process.
Sure. So the first case that we're going to review is agenda item number 48 regarding Mateo Payola.
He is online.
And he is on. See you later.
And I would add that
Please.
the idea is we would hear from him but not vote. Then we will hear from the remaining group, and then we will bring him back in. We can vote on them, simply so that you have the full picture of all the people who want to speak on this matter.
And so, thank you, Director. So that comment by you would apply to all of the other items between 45 and 50, or just to 48, 49, and 50?
So it's actually 48. You would hear that one and not vote.
That vote.
And then 45, 47, and 49 would be heard together.
Okay.
Then you,
And then after that, we would hear the last ones on this queue. Is that right?
No,
sorry.
no, the reason is that number 46 and 50, the respondents in those two cases will not be attending. And so the thought was to have you vote after hearing the arguments in 47, 45, and 49,
Okay,
then go back to 48.
please, all of you, keep me straight. You need to remember that I'm an old person and I forget what you just said 30 seconds ago. So we will now proceed to item number 48 involving Mateo Paola, if I'm saying his name right, and Mr. Paola is on the line.
Yes, sir.
Mr. Esparza. Okay, we'll now move to item 48. Mr. Paola, can you hear me? I see your picture.
Yes.
Thank you for joining us. Thank you. Let me do that.
Thank you.
My name is Dave Fiscum. I'm the chair of the Oregon Government Ethics Commission. What we're going to do today is hear your item in the following way, 5 parts. One, there'll be first a presentation by our investigator. Second, a time for us as commissioners to ask our investigator questions. Thirdly, a time for you to make any comments you choose to make. And if you choose to make some, which is your prerogative, please at the time identify yourself for the record. Fourthly, a time for us as commissioners to ask you any questions that might come up across our minds. And fifth, a time for the commission to discuss and make a decision on the issue before us. That said, we will turn to Investigator Fenstermaker for a comment on item number 48, please.
Sure. Good morning, Chair Fiscum and Commissioners. My name is Casey Fenstermaker. Agenda item number 48 is regarding Mateo Paola, a council member for the Associated Students of Oregon State University's Judicial Council. ASOSU is the student body government for Oregon State University. On July 18th, 2024, the Judicial Council held a closed meeting. In the meeting, the complainant alleged the Judicial Council members deliberated regarding the authority of another ASOSU committee. The Judicial Council determined that they are not subject to public meetings law, in part on advice from OSU's General Counsel, that they are not a governing body and therefore not subject to public meetings law. Based on the information reviewed during the preliminary review, it appears ASOSU is a public body and the Judicial Council is a governing body. ASOSU performs various governmental functions. It is part of a shared governance structure with OSU, with shared responsibility for the governance of OSU students. ASOSU is required to be included in various commissions, committees, councils, work groups, and other university governance structures to contribute to OSU's decision-making process. Most compellingly, ASOSU makes recommendations of the amount of the mandatory incidental fee, including its allocation and distribution. The Judicial Council is a governing body. If the Judicial Council is a governing body, and the Judicial Council interprets applicable rules and processes of the student government, interpretation of the ASOSU Constitution, interpretation of ASOSU statutes, among other things. It appears the Judicial Council is making decisions or recommendations on policy and administration for ASOSU. Based on the scope of its authority, it appears to be a governing body subject to public meetings law, and therefore it appears it should have held the July 18th, 2024 meeting in accordance with public meetings law. As there is a substantial objective basis to believe the Judicial Council violated public meetings law, the preliminary review report recommends this case be moved to investigation.
Thank you, investigator. Any comments or questions for our investigator before we proceed further? Colleagues,
No questions.
please, Mr. Thompson.
So I understand, I don't know if this is for Casey or for Sean, but I understand ASOSU being a governing body and falling under public records law, just as, other executive branch things are in the state of Oregon. My question is, obviously, like a court in Oregon is not under public meetings law. And is that where this group is saying they fall under, and that's where we have our issue is? I mean, I'm trying to figure out how this, I understand that ASOSU as a whole is just as Marion County is, but the Marion County Circuit Court is not. So I'm trying to figure out how this fits together or doesn't.
Yeah, and that is one of the arguments that the General Counsel for OSU had made, but this is not a judicial body as defined by the DOJ opinions.
So
Is that fair, counsel?
Yeah, so it's a judicial organization within that's advising essentially a legislative type body or an administrative type body. It's not a judicial body under the judicial department of the state of Oregon. It's that.
Does that help?
So what, just to make sure I'm following, Oregon statute defines specifically what a judicial body is. It doesn't simply, a statute doesn't simply say judicial bodies are exempt from public meetings law. It says these judicial bodies are exempt.
It does not specify that the judicial body, it does not like name judicial bodies in statute, but a judicial, I'd have to go back to the exact language, but it would not encompass quasi judicial actions, which this essentially is. So these are not true courts in the sense that they have the ability to make a binding decision on a legal matter that's subject to the state of Oregon's jurisdiction. This is a quasi judicial matter that they are considering, among other things that they're doing.
Okay, thank you. Thank you, Mr. Chair.
I've got one question for the investigator, and maybe the way to ask this is to say, can you repeat something I think you said earlier, which is that some legal counsel was provided to this group by OSU's legal counsel to the extent that it was not a public body? If I have said that badly, I apologize. Can you clarify what you originally said on that point?
No, you are correct. They were provided counsel by OSU's legal team that they were not subject to public meetings law for both the judicial component argument and the fact that they were not a quote unquote governing body.
And the upshot is that we disagree with that advice.
Correct.
And last question, which I don't need an answer necessarily, but if somebody relied on legal counsel's advice in such an instance as that, does that provide any protection for the person who so relied on that advice?
Chair, there are provisions in our penalty matrix that provide,
Okay.
Some safe harbor. The actual, we cannot bring any civil penalty, only applies for the advice under the public meetings law statutes. But yes, we have deducted points on the penalty matrix so that if they are relying on the advice of counsel,
That's a mitigating factor.
it's a mitigating factor.
Thank you for that. That helps me remember part of my past. Thank you very much. Colleagues, further questions for our investigator, if any, or executive or counsel, any of those? Hearing and seeing none, Commissioner Payne, I apologize. I see your hand. Please proceed.
That's okay. Thank you, Chair. I just want to also kind of, analyze this judicial council, and it seems to me that they're not deciding disputes that come before them. They're interpreting law. They're interpreting the OSU's or the public body's rules, and they're advising on those rules, which to me is much different than a traditional judicial body, which is deciding disputes that come before them. So for me, that's critical in not determining that there's some sort of traditional judicial branch or of government, as they're calling it, because they're not making final resolutions of disputes. That seems very different to me. So I just wanted to make that comment for the record as well.
Commissioner, comments about that? Anybody? I know you're trying, Commissioner, Executive Director Myers, please.
And I'm sure the students may clarify for the commission what kind of actions this judicial council makes. What I would point out is that the commission has, and the Attorney General has issued advice and opinions clarifying that the judicial proceeding exemption to public meetings law 192.690, I believe it's sub 1L, applies only to judicial proceedings originating in the judicial branch. And so all other judicial proceedings, including proceedings quasi-judicial, including our own proceedings,
Yeah.
including tax appeal hearings at the
Right.
city of Portland are not within the judicial branch.
Right, and I recall that opinion also determined that administrative proceedings, like administrative disputes coming before administrative bodies, were not within the judicial branch, and therefore, because they didn't originate in the judicial branch, also were not did not fall within that exception. Right? Am I recalling that correctly?
Commissioner heads are nodding in the affirmative. Thank you for your comment and question. Please proceed if you have a follow-up.
No, thank you.
Thank you. Any other colleague, any other questions or comments? Hearing and seeing none. Mr. Paola, if I'm pronouncing your name right, this is your time to make any comments to us. Just a couple things. First of all, when you do so, I presume you're going to do so, please identify yourself for the record. And we'll ask you to be expeditious in your use of our time. We're on a tight schedule today, but we want to give you a chance to make your comments. So please proceed. Thank you for being here.
Awesome. Thank you, commissioners. My name is Mateo Paola. First of all, I just wanted to address the JC did at one point decide to exempt themselves from public meeting law. I was not a counselor at the time. If I were, I would not agree with that ruling. I don't think a governing body has the ability to just decide to exempt itself from the law. But I'm going to go ahead and read what I've part of the statement. As a counselor and not the chair or an officer vested with the authority to call meetings of the council or determine their time, location, or postings of notice, I can reasonably say I have done everything in my power to push the council to meet publicly or otherwise in compliance with Oregon public meeting law. I have attempted to do so prior to my service on the council and while on the council prior to the submission of this report, and continue to attempt to do so. However, I've been outnumbered and unable to do anything but show up and make my objections clear, verbally and in writing. Throughout this process, I have received absolutely no support from advisors hired to advise members of the ASOSU and was unsure what steps to take exactly beyond the steps I've already taken. I was actually in the process of drafting my own report against the council until the complainant in this case had informed me that they would be submitting one. When it comes to the complaint, I have worked with the complainant to support the submission of the initial report against counselors, and they've indicated that I've satisfied their grievance with myself, even though the rest of the body has failed to do so. If an investigation is to be pursued, I'll do anything necessary to assist OGEC in their investigation. If you have any questions about how the JC works or anything in general, I'm happy to answer them. Thank you.
Thank you, sir, for being here and for the candor of your remarks. We appreciate it. I appreciate it. All of us appreciate it. Any questions for our respondent, Mr. Paola, if I'm saying your name right? Colleagues, questions? Okay, the fifth step in our procedure is to decide on this issue, but we're going to delay that until we hear other matters related to this issue from other respondents so that we have the full scope of information before us, probably make individual decisions on these matters. So Mr. Paola, again, thank you for being here and for your remarks. We appreciate it. We're going to excuse you for the moment and we'll call you back when the time comes for a decision, but thank you for being here.
Thank you.
Colleagues, the process now, Investigator Finstermaker is to hear items 47 and 49 together. Am I right?
45, 47, and 49.
You want 45 included in that. Thank you for emphasizing that. We'll now consider items 45, 47, and 49 together. Those individuals have waived confidentiality, if I'm going to assume the fact not yet in evidence.
Yes, so they waived confidentiality to each other as well as to OSU counsel Leonie Reeves and a support person, Carrie Simonette.
Okay, as our staff admits those persons either already or in a moment, the question comes before us, as I understand it, and investigator and director help me with this. Other individuals will be allowed in because confidentiality has been waived, but those others allowed in would not be ones who would be testifying before us on these matters. The only ones testifying before us on these matters at our direction in a few minutes would be the respondent and his or her legal counsel, if counsel is there. Is that accurate?
So I will
Please
say,
clarify for the record.
sure. So it is within the commission's discretion
Yep.
to allow counsel for OSU because counsel for OSU is not the student's
Right.
personal attorney. So it is your discretion as the.
To allow that person into the proceeding without necessarily taking step two, which is to allow that person to speak on the record.
So,
And our process normally is not to allow such in a matter of routines before us. Those who are allowed to speak to us are the respondent himself or herself and his or her counsel. If permission is granted for others to be there because confidentiality has been waived by the respondent, those persons can listen and participate by that method, but not speak to us. That's our typical process. Am I right, Director?
that is correct.
If I have said that badly, please clarify.
Yes, that it is within the commission's discretion both to admit them and then separately, it is within the commission's discretion to allow or not allow someone other than the respondent and their attorney to speak. As you point out, typically our practice has been that only the respondent and their attorneys can speak. But again, it is the commission's decision.
Thank you, Director. Let me tell my colleagues how I would intend to proceed today, though I'm open to any comments from colleagues about this process. Obviously, we have three respondents before us who have all waived confidentiality. If they happen to have counsel with them who represents them, those persons are allowed to speak. Others who will be in the room with our permission granted, and I would grant such permission, will be able to hear and participate by that means. But my proposal is that those persons not be allowed to speak before us because that is our usual practice as such matters come before us. If that makes sense, colleagues, I'm happy for your reaction to that. If you would have a different approach, I'm open to it.
Sure.
Commissioner Thompson, please.
I don't have a particular objection to having counsel for OSU speak. I mean, I think they're part of OSU. This is OSU's counsel. I don't have a problem with it. I understand that it's not a personal attorney matter, but I have no problem with counsel for OSU speaking should they want to.
I don't either in one sense. It's to make the point I made earlier, and I'm okay with if we do this. That's a different procedure than as a commission we normally use. And so one of the things that I look at my legal counsel and say that sometimes the word precedent tends to be in the eye of the beholder. And are we setting a precedent here if we allow such testimony? And if the answer is yes, that's okay. If the answer is no, that's in our own judgment. So colleagues, Commissioner Payne, McCauley, Burke, any comments on that issue of allowing OSU's counsel to speak today?
Chair, is it possible that we could leave it up to respondents that if we could let either respondent speak, or if they have chosen to have OSU attorney speak on their behalf, that they could do so, but our procedure is that respondents would speak on behalf of themselves. However, if they have chosen to have OSU speak on their behalf, the OSU lawyer speak on their behalf, we would not object to that, but it would be either or.
Commissioner Payne, I agree with you. I'm with you on that score. I'm presuming if the head's not around the room, that our colleagues are okay with that. I see Commissioner McCauley and Commissioner Thompson saying that that's okay. Let's proceed in that direction. Colleagues, respondents who are appearing before us, I see all your pictures. Thank you for being here and responding to our agenda today. My name is Dave Fiscum. I'm the current chair of the Ethics Commission. Our approach today will be of 5 parts. It is as follows, briefly and quickly. We will hear first a presentation by our investigator on your issue, which are embedded in our items 45, 47, and 49 on our agenda today. Right, investigator? Thank you.
Yes.
The second step will be a time for us as commissioners to ask our investigator questions if we have questions. Thirdly, a time for you to make any comments you choose to make for the record. And if you choose that option, which is your prerogative, please identify yourself at the time for the record, and we'll be happy to listen to what you have to say, including if you choose to have the OSU Council speak into this issue. We'll be happy to accept those comments. Fourthly, it'd be a time for us as commissioners to ask you questions if on the basis of what you said we have any questions. And last, a time for us as a commission to discuss what decision we would intend to make on these matters before us. That said, Investigator Fenstermaker, please.
Yeah, so I just wanted to note that Carrie Simonette, who the respondents have requested be in attendance, they're working on getting her into the meeting. Staff is working on it. But with your permission, I'll move forward with my script.
Can we proceed pending that additional arrival?
Yep, that's what I'm asking.
Thank you.
For permission to do, yeah.
Please do.
Okay.
Thank you.
Agenda items 45, 47, and 49 are regarding Madison Jones, Colin John Carmichael, and Anna Godfrey, council members for the Associated Students of Oregon State University's Judicial Council. ASOSU is a student body government for Oregon State University. On July 18th, 2024, the Judicial Council held a closed meeting. In the meeting, the complainant alleged Judicial Council members deliberated regarding the authority of another ASOSU committee. The Judicial Council determined that they are not subject to public meetings law, in part on advice from OSU's general counsel that they are not a governing body and therefore not subject to public meetings law. Based on the information reviewed during the preliminary review, it appears ASOSU is a public body and that the Judicial Council is a governing body. ASOSU performs various governmental functions as part of a shared governance structure with OSU, with shared responsibility for the governance of OSU students. ASOSU is required to be included in various commissions, committees, councils, work groups, and other university governance structures to contribute to OSU's decision-making process. Most compellingly, ASOSU makes recommendations of the amount of the mandatory incidental fee, including the allocation and distribution of those fees. The Judicial Council is a governing body. The Judicial Council interprets applicable rules and processes of the student government, interpretation of the ASOSU Constitution, interpretation of ASOSU statutes, among others. It appears the Judicial Council is making decisions and recommendations on policy and administration for ASOSU. Based on the scope of its authority, it appears to be a governing body subject to public meetings law. Therefore, it appears the Judicial Council should have held the July 18th, 2024 meeting in accordance with public meetings law, as there is a substantial objective basis to believe the Judicial Council violated public meetings law. The preliminary review report in this matter recommends moving this case to investigation.
Thank you, Investigator. Then Ms. Simonette, you've arrived. Can you hear me? I see right now you're muted. I'll assume you can hear us.
I can.
Thank you very much.
I can. Thank you.
I described earlier our process today. We're at the second step of the process, which is commissioners will ask our have the freedom to ask our investigator questions if anybody has any questions. Now's the time, colleagues. Any questions for Investigator Fenstermaker? For the moment, hearing and seeing none, there'll be more chances for this. The time has now arrived for those appearing before us to make any comments they choose to make to us on the record in this executive session. Please feel that freedom. I'll expect you to appear to speak in any order you choose. It's up to you. As you speak, please identify yourself for the record, and Ms. Reeves will be happy to hear you if these respondents want you to make any comments on their behalf to us as well. So welcome. Who's first?
I can go first if that's okay with
Ms.
everybody.
Godfrey, please, we'll listen to you. Identify yourself for the record and proceed.
Hello, commissioners. My name is Anna Godfrey, and I'm currently a member of Oregon State's Judicial Council as not only a member, but I'm also the Ethics and Compliance Counselor. I want to thank you all for your time and consideration of our cases and for your dedication to maintaining Oregon's strong ethical standards. The Association of Oregon State, or the Associated Students of Oregon State University, or ASOSU, is, as Detective Fenstermaker stated, is the official institution of student democracy on OSU's Corvallis campus. While it has some delegated governmental functions, such as setting student fees through the Student Fee Committee and the ASOSU Senate creating legislation, its primary role is educational, helping students learn relevant life and professional skills. The ASOSU Judicial Council role is to interpret the ASOSU Constitution, statutes, and procedures, providing guidance on how ASOSU should conduct its business. It does not make any administrative policy decisions, and the council's function is not governing in nature. Its decisions are not binding, they are advisory. The Judicial Council's meetings, including the one on July 18th, which discussed the interpretation of ASOSU statutes, has historically never been considered subject to Oregon Public Meetings Law prior to this incident. The stance is consistent with OSU's longstanding position and guidance from the Office of General Counsel, which the JC has relied on in conducting its work for years without objection. To further note, the ASOSU Senate passed a piece of legislation making it mandatory for the Judicial Council to follow Oregon Public Meeting Law, regardless of the outcome of this matter. Thus, from July 18th on, we as a council have been compliant to the best of our abilities to follow public meeting law and will continue to do so. In congruence with my previous statements, I would like to include that I and my fellow judicial counselors were performing our official duties in good faith on July 18th. I myself had only been a counselor for about 2 weeks when this incident occurred. I was unaware of the impact that meeting would have on me in the future. As a new counselor, it was frightening to receive notification that I was a part of a complaint submitted to the OGEC. I joined the Judicial Council with hopes of honing my skills as an aspiring professional in the field of public service and law. I'm currently a double major in public policy and sociology at Oregon State, as well as it's a great supplemental activity that benefits my education greatly. I was under the impression that ASOSU was a safe space for me and my coworkers to practice real life skills like collaboration, navigating differences of opinion, and learning governmental procedures like this. I did not expect to go from simply hearing a writ to being a part of a preliminary investigation by the OGEC. I didn't join ASOSU for my own financial gain or any sort of personal agenda. I barely make enough money to cover like a singular tank of gas, much less like to pay rent or do anything like cover student expenses. And I believe that I and my fellow members choose to fulfill our duties as public servants to the student body of OSU out of our own passions in our own good faith. I am also concerned as to how this situation will impact my future. I graduate in less than 6 months. With hopes of attending law school and practicing law in the future. And I'm just not sure how this could affect my professional goals, as I know that to be a lawyer and apply for the bar and all that, you do have quite extensive ethical background checks and such of that nature. And I would be deeply saddened if my service on the Judicial Council put that in jeopardy. I hope that this statement aids in your consideration of how to proceed with this matter, and if any clarification is needed or if I can be of further assistance down the road, please feel free to call upon me at any time. Thank you all.
Thank you, Ms. Godfrey. Some of us may have some comments or questions for you in a moment, but rather than move to that right now, I want to call on a couple or three other of your colleagues. I'll take initiative to call on Ms. Jones. Please feel free to make any comments to us, and within reason, feel no obligation to repeat what Ms. Godfrey has said, but if you have anything to add, we'd appreciate hearing from you. Ms. Jones, please proceed, and you're on mute if that matters. Ms. Jones, we still can't hear you. Not sure why. Can't hear you for the moment.
She is off mute, so it's something that's on her end.
You're off mute now by our signal, so there's something that is preventing you from speaking for our hearing. So you can think about how to work on that in the next moments. And with your indulgence, I will call next on Mr. Carmichael to make any comments, and we'll try to get you back on the record in a moment. Mr. Carmichael, please proceed.
Thank you. I assume, can you hear me?
Yes.
Okay, awesome. Thank you. Members of the commission, thank you for the opportunity to provide a statement. My name is Colin John Carmichael. I'm a sophomore undergraduate student at North Carolina State University, majoring in biomedical engineering. I was a student at Oregon State University Honors College from September 2023 until June 2024. And I served on the Judicial Council of the Associated Students of Oregon State University from January 17th, 2024 until September 24th, 2024. I was elevated to the position of Ethics and Compliance on January 25th, and I also resigned from that position at the same time as I resigned from the council. I joined student government to practice collaboration, compromise, and communication in an environment designed to teach young adults about the function of modern democracy. My work in student government was always in the interest and service of the student body. To provide some background, the Associated Students of Oregon State University, ASOSU, is the officially recognized student government at the Oregon State University's Corvallis campus. The earliest electronic evidence from the judicial branch of ASOSU is a majority opinion from 2009, but it's safe to assume that there has been some sort of judicial branch of the student government since its founding in about 1900. The Judicial Council's authority is conferred by the ASOSU Constitution, and its role is to interpret three things: the ASOSU Constitution, the statutes, and all other internal governing procedures, such as appendices, the internal code of conduct, and the standing rules of the student government's various committees. The Judicial Council cannot make substantive decisions about the mandatory incidental student fee. It is limited to the interpretation of internal procedures. The council may provide a non-binding advisory or an internally binding opinion on how the student government should conduct its business, but that, of course, is limited to internal procedure. Around the beginning of March of this year, the Judicial Council received a written grievance as required by state law to initiate a complaint to the Oregon Government Ethics Commission. The complaint was responded to by the former council chair within the required timeframe, and it contained all the needed elements. The council provided a further more formal response in its opinion on the writ numbered 24031R. I believe the commission has access to that writ. This response did not self-designate the council as a body not subject to the PML, the public meetings law. Rather, it provided kind of a further explanation of the council's position on the matter. This opinion had no binding effect as to the council's legal status as a body. Of course, that's left up to the Attorney General's opinions and the commission. ASOSU's primary role is to serve as an educational activity to help students learn how to work together. The determination of the mandatory incidental student fee is a discrete task that is equal to the exercise of governmental power. However, this task is delegated to the Student Fee Committee and the Student Senate. This task is not delegated to the Judicial Council whatsoever. The complainant who initiated the grievance on February 21st never, to my knowledge, submitted the complaint to OGEC after repeatedly taunting myself and the former council chair with the prospect. However, this complaint was filed, I believe, in late August in regard to a meeting of the Judicial Council heard on July 18th, 2024. In that meeting, the council heard the writ numbered 24037I, which you should also have access to. This writ was asking the council to make an interpretation about the Student Fee Committee's role in the fee setting process, according to the ASOSU Constitution and statutes. So in that meeting, the council interpreted the internal Constitution statutes and effectively opined that the Senate should just continue what it has done historically concerning the authority of the Student Fee Committee. So never in ASOSU's almost like 120-year history has the Judicial Council been considered to be subject to the PML. And there's been no objection to the Judicial Council's procedure in this way until now. And this is because the council's not a governing body. It does not make decisions or recommendations to a public body on policy or administration. The very nature of the council's decisions is fundamentally different than that of the Student Senate. The council's internally binding decisions do not decide how the university's board of trustees will move on an issue of policy or administration. And essentially, the Judicial Council does not deliberate or decide on the actual student fee. And it did not make such a decision during its meeting on July 18th. The deliberation and decision of the student fee, the monetary value, is done by the Student Senate. The majority opinion from the meeting on July 18th, that's the 037I in your documents. It proves that we didn't make any sort of determination of that nature. The text of the opinion doesn't actually mention any monetary value of any part of the student fee. It's entirely regarding internal procedure, as you'll see. Between the submission of the written grievance in February and the council's opinion expanding on its response that was given on April 25th, the Judicial Council received the university's official position and further guidance from the Office of General Counsel that the Judicial Council is not subject to the OPML. So since that position and guidance was received in March of this year, the council has acted and operated under that guidance, continuing to hold meetings as we have for the past 15 years. It's worth mentioning, as Ms. Godfrey did, that since July 18th, that meeting, the ASOSU has adopted legislation that voluntarily obliges itself to follow the OPML. So moving forward, this issue will essentially become moot. I want to end by mentioning that the three of us here and the other three respondents to this complaint work in a mostly volunteer capacity for the student government. We were all working in the interest of the students, and we had no malice or ill will in this matter. We are college students. I'm 19 years old. I just started a full-time job about 6 months ago. Given the information that I've provided today and Ms. Godfrey has provided and what Ms. Jones will provide, I don't see it an appropriate use of the commission's time, money, and resources to investigate this complaint against college students. Ms. Godfrey is a future lawyer and Ms. Jones is a future dentist. The impact that an investigation would have in this stage of our professional careers is significant. I ask that the commission consider this while making a decision in this case. For these reasons and the facts mentioned above, I request that the commission dismiss this complaint. Thank you for your time, and I welcome any questions you may have after you hear from Ms. Jones.
I have a question regarding the recent change to what you said, voluntarily start complying with public meeting laws. Is it now the official policy of Oregon State University that the judicial council is required to follow public meetings law such that it will do so for time memoriam, or is it just voluntarily doing so for the time being such that at any point in time it could reverse that voluntary compliance and go back to its official position in its legal memo prior to July and stop complying with public meetings laws? And I'm
Thank
not
you.
sure who to direct that question to or who wants to answer that question.
I would hope if Ms. Reeves is able to answer that question, I would direct that to her. If not, I would be happy to answer in the best of my abilities.
I'm happy to hear from Ms. Reeves on that question.
Good morning, Chair and Commissioners. Thank you for allowing the students the opportunity to speak and the opportunity for me to be here. I would say that the decision was made by the ASOSU as student government. It is not a decision that was made by the university. Again, this is a student democracy that engages in self-governance, and they have made the decision in the current constitution of their student government to make that policy change for their own internal procedures. There has been no direction from OSU to do that, and so the student government would have the freedom to change that decision in the future if that's what you're asking.
Ms. Reeves, would you do me a favor and identify yourself for the record, having just made the statement you made? If you can't hear me, I apologize for that, but please identify yourself for the record and enunciate your position that allows you to speak today. Please do so.
Thank you, Chair and Commissioners. This is Leonie Reeves. I'm an attorney with the law firm of Miller Nash, and I am here in my capacity as outside legal counsel to Oregon State University.
Thank you. Commissioner Payne, any follow-up on that question?
Yeah, and just to clarify, there's no that they could change that tomorrow, that internal policy decision that they made. I'm just to understand your answer, they could change that decision at any time. The students could.
As my understanding of the decision that, and the sort of the scope of the decision that was made, that was an internal decision of the ASOSU, and yes, they could change that if a future or current ASOSU had a different vote on that. But I would welcome any of the students who participated in the adoption of that particular legislation to offer any additional insight that they may have on the longevity of the particular legislation that was passed.
Thank you, Ms. Reeves. I don't see Ms. Madison on the line anymore. Maybe she is on the phone. We were having just some difficulty hearing her. It may not be necessary for her to speak if there's nothing additional to add. But Ms. Adams, pardon me?
We're re-admitting her now.
Okay,
May I ask a question for the record?
just a second. Ms. Madison, can you hear me now?
Yes, can you hear me now?
Yeah, hang on just a second. Commissioner Thompson has a comment to make and then we'll proceed. Please just hang.
Just wanted to put something on the record in response to Ms. Godfrey's testimony. Just to be clear, we may be the Oregon Government Ethics Commission, but a public meetings law violation is not an ethics violation. Am I correct in stating that?
Correct.
Okay, thank you very much.
And I would only add, I can add this later as well, that depending on what our action is, underline if, we decide to move forward today, that is not the declaration of a violation, Ms. Godfrey.
What button did you push?
Ms. Godfrey and others, that is not a declaration of a violation. It is the expression of a need for more information. And as I've said many times on the record to folks, you included, that is a distinction that's often, in my judgment, not well understood. But it's a very fact of our process. So please understand that as any of you college students look forward to your future, what we do today, if we move, won't affect that in the sense that it's not a violation of anything. It's you're dealing with a state government agency that needs more information. So that said, we'll hurry on to proceed. Ms. Jones, do you have anything else to add to what your colleagues have said? And for the record, you appear to be on mute again, so please unmute yourself, identify yourself for the record, and make any brief comments you choose to make to us. Please
Hi,
proceed.
my name is Madison Jones, and I am the current Judicial Council Chair. And I want to start off by saying I'm sorry my microphone wasn't working. I think my computer is kind of on the end of its lifespan today. But I think a lot of my statement is going to a little bit reiterate what Colin and Anna said, but I think it's important to share from my perspective as well. When I first joined this job, it was only because I grew up with a background in community service, and I actually volunteered on a youth advisory board throughout high school, and I loved it. I loved the opportunities, the friends I made, and just getting to help others, because I think it gives you a greater appreciation for those around you and just your community as a whole. And I think it helps a lot with communication skills and being able to see eye to eye with people. So I saw this position as the opportunity to give back to my university and be involved in something greater than myself. And kind of as Anna said, when I first joined, I was barely making any money from it, maybe $16 a month, if that. Sometimes we would even go months without making a single dollar. Despite this, I still wanted the job because I wanted the experience and the opportunity. Even as the chair, I wouldn't say I make enough money to pay rent or student loans or afford bills. My sole purpose of being on this council is for the experience and the chance to build connections. So when I was recently elected a chair, I was left very large shoes to fill. Everyone before me seemed very knowledgeable and could answer things at the drop of a hat. So it was an understatement to say I was very nervous to be given such a great responsibility, given the previous chairs before me. And my very first meeting was the July 18th meeting in this role. Nonetheless, I navigated this council the absolute best of my ability, and I feel as if I've chaired this branch in a manner that is impartial and truthful, and overall just respectful to those that we work with. We have always been big on transparency and truthfulness for as long as I can remember. And we've always been happy to discuss any decisions or thoughts outside of meetings, so everyone has an opportunity to be heard and decisions can be further understood. And I feel like it's important to state that nobody has ever been left in the dark based on the order of our meetings. And I'm about to graduate from Oregon State, which is exciting, but it's also not the end of my academic pursuit because, as Colin said, I am applying to dental schools. So I have a long road ahead of me still. And at this point in my career, I think this just kind of whole process really scares me. And I don't know how it's going to affect my career and just how employers are going to view me. So when I found out we were being potentially reported to OGC for not following public meetings law, I was very distressed. I truthfully thought I was doing everything I was supposed to, and I couldn't help but feel as if it was a politically based decision to submit this report against my peers and self. As our role has never been challenged like this until recently. Sorry, I'm just a little bit overwhelmed. I asked the general counsel for advice because I didn't know what to do. This experience was very overwhelming and it was new to take on. And I feel like I kind of failed my peers. I never knew that we could possibly, I'm sorry, be subject to something like this. And I've never governed, our branch has never been governed in this way in any of our years of operation. And none of the universities and judicial branches in the state of Oregon have been conducted in this way beyond Portland State by choice. And I feel like that's also really important to look at because we would not be the only ones in this matter. And we have never been able to commence binding authority or make decisions for any public body. So I was never under the impression we could be violating anything. And our only role is to conduct a general interpretation of governing documents and nothing more. So when our meeting during July 18th, we were simply analyzing a committee's role and not defining any fees or giving any further rules or laws around that. Just interpreting the role of a committee within ASOSU. Ever since we've received our initial letters, we have been diligently acting under public meetings law to avoid any conflict. And I would never intentionally guide this branch or my peers into doing anything wrong or jeopardizing their future. And I just feel horrible that everybody feels this way. And I'm sorry, I didn't mean to cry. I just get really emotional about these things. I'm sorry.
Thank you, Ms. Jones. Please feel no hesitancy or sensitivity about emotion because we understand that. And thank you for appearing today. And I want to move us along with all due respect to you and your colleagues and ask a final time for Ms. Reeves if she has any general comments to make to us. The students have authorized you to speak as not their legal representative, but on their behalf, if you choose to add anything. And please comment if there's something to add from your perspective. Thank you.
Thank you, Chair and Commissioners. Again, for the record, this is Leonie Reeves, Legal Counsel for Oregon State University. I believe that the students have well articulated the position, both from sort of a legal perspective of why the governing body, the Judicial Council is not a governing body of a public body, and the limited scope of what they do is very different from what the Student Fee Committee or the Senate of the ASOSU does. It's very different role and a very different set of authority of what they do. And so I think that they've articulated that, and they've certainly articulated the impacts of this process. And I don't want to take away from anything they have said, because I think that they've all said it in their own words very well. But thank you for the opportunity to speak.
Thank you, Ms. Reeves. Now is the time, colleagues, to ask any questions of any of these respondents. We've had a couple questions already. Commissioner Payne, thank you for asking your question. I see the hand of Mr. Burke. Commissioner Burke, please ask your question. Commissioner Burke, you're on mute.
Okay, can you hear me now?
Yes, please
Okay,
proceed.
very good. Thank you very much. I didn't have so much a question as a comment for Madison, or excuse me, Ms. Jones and the other ones. I'm sorry you're upset. I was once the president of the Student Senate at Portland State University, and we had our difficult times as well. Very frustrating, very upsetting. And government can do that to you. It can create those times. And interestingly, that too is part of the learning experience that you're gaining when you're taking on something like this. But we have had many people come sitting where you are now who are good people. This is no reflection on you failing your students. Everybody makes mistakes. A lot of people don't have the training on these things that they need to do things successfully. But what they all learn is that the sun will rise tomorrow. And although I cannot with 100% certainty guarantee that no one will ever notice this, I can tell you from my experience and the mistakes I've made and those that my friends have made and people that I know in government, that this is not going to be a black mark on your career. Student government is a sandbox, to make mistakes in, to do things with. And so I want to encourage you, it's good that you're concerned about these proceedings, but you're going to be okay. And I can tell you're all good people who want to contribute to your communities, contribute to your schools. And I want to thank you for doing that. And whatever happens today, I just want to let you know that you're going to be okay and that this is going to end up being a good experience for everyone and probably good for your school. Thank you, Mr. Chair, for indulging me.
Thank you, Commissioner Burke. Appreciate your comments. Commissioner Payne, please.
Thank you, Chair. I just want to piggyback off of Commissioner Burke's comments, and I want to thank our respondents today for their candor and also for your service to the Judicial Council. You all are very bright. I'm so impressed by your comments today, your intelligence, and I think you all have very bright futures. This is always a difficult situation when we have people come before us, like Commissioner Burke said, who, want to do the right thing, don't always understand their obligations. And, this commission is all about education. And today we are not deciding whether any violation has occurred. We're just deciding whether we're going to move to investigate potential violations. And whatever ends up happening, this is, again, our primary goal is to educate and inform. So, we can help your body understand its obligations. And so, we hope that goal is going to be fulfilled. But, again, Commissioner Burke's right. This is, this is not a complaint regarding an ethics violation. This is a complaint regarding a potential violation of, public meetings laws. So I hope that puts your mind at ease a little bit, and you guys all have bright futures ahead of you. And, I thank you for all the work you've done. And again, we're not deciding today whether any violations have occurred, but just whether we're potentially going to investigate those violations.
Thank you, Commissioner. I will associate myself with your remarks. Colleagues, we have essentially moved already into the process for deciding on this issue, on these issues before us. We're not going to decide immediately. I want to ask a question about the decision, but let's keep discussing this issue or ask any questions of our respondents. I will merge those two objectives into one and see if anybody else wants to participate.
Do we have to hear from the next people?
No, they're not.
So we make decisions on these matters before us individually, not collectively. Am I right?
Correct.
Thank you. So we will be, colleagues, just in terms of our process, we'll make decisions individually on item 45, then 47, then 49, and we'll do those individually when the moment arrives. First of all, I see a hand from Commissioner Burke. Do you have a further comment, Commissioner?
Yes, I do, Mr. Chair. My previous comment was meant to sort of let the respondents know that everything's going to be okay. But on this comment, what I would say is that Oregon State University is a tax subsidized organization. The governmental bodies, including student government, are tax subsidized. You have not the authority to allocate funds. You can recommend and do all those other things, but you do have the authority to represent the student body on public issues. You're their voice, so to speak. And so I'm not an attorney, and I may be wrong, but it seems to me, having been in student government myself, that the body is obligated to follow public meetings laws. And, the process we're going through now is part of the learning experience that you're getting by being involved. So without stating whether or not a violation has actually occurred, I would support a motion to investigate this further and get more information and perhaps get some legal advice on how this applies. So that is my comment, Mr. Chair. Thank you.
Thank you, Commissioner. I'll assume that's not yet a motion because we have a further discussion from Commissioner Thompson, among others.
That's correct.
Thank you.
Thank you, Mr. Chair. This group talked to their legal counsel. They got advice. They have fixed the problem moving forward. Based on the fact that they talked to legal counsel, the most we can do realistically is issue letters of education. But I feel like we've educated. So I'm just not sure what we gain by moving this forward any further. Now, I appreciate Commissioner Payne's comments about the fact that they're voluntarily complying with it and they could go back. I think if they do go back, then we have another discussion to have. But for now, I feel like the issue has been fixed. The students involved have received education and they've come before us, and I hope today was educational as well. But I just don't see what moving this forward will do beyond what has already been done.
Commissioner, appreciate it. Any comments about Commissioner Thompson's comment or other questions of a general nature? Two hands are up now. Commissioner Burke, then Commissioner Payne. Commissioner Burke, please.
Yes, I have one more comment. I would generally agree with Mr. Thompson's comment. The one place where I would disagree is that if I understood legal counsel for the students correctly, this policy of adhering to public meetings laws could be rescinded at any time. That to me is a problem. And also combine this with the fact that student governments have very high turnover and there's not a lot of institutional memory. And so I think that what a letter of education would do, if we decide that there has been a violation and issued a letter of education, I think it would close that loophole. I think that it would make it much more difficult for the student body to decide it was not subject to open meetings law. And I think that would be something that would last the rapid turnover of the student government membership.
Thank you. Commissioner Payne, please.
Thank you, Chair. I second Commissioner Burke's comments. I also have concern that there's a legal opinion from Oregon State University's counsel that the Judicial Council is not subject to public meetings law. And I think that a letter of education from us outlining that they are subject, I think would also sort of prevent that change in position from the students in the future with that turnover that Commissioner Burke was talking about. And I think that's important because even though these students that are serving now, have decided to voluntarily comply, I think that would prevent rescinding that policy tomorrow or the next day or the next month. And so I do think a letter of education could be particularly valuable in this situation. Whereas, again, normally I might agree with Commissioner Thompson, but I just don't considering these particular facts.
Thank you, Commissioner. Your director in a moment. Commissioner Thompson first.
Thank you, Mr. Chair. I would agree with Commissioner Burke and Commissioner Payne on a letter of education if the letter of education was issued to the university or ASOSU, but because, and correct me if I'm wrong, letters of education are issued to individuals. If the turnover happens that Mr. Burke is talking about happens, the next person is going to have no idea that this letter of education even exists. So, I mean, I see the problem, but I'm not sure that us issuing a letter of education to somebody who then turns out not to be on the council next time this comes up fixes that problem.
Executive, please.
So what I was going to say may answer your question and provide an alternative. The commission, our legal counsel reminded me, the commission has the authority to issue a commission advisory opinion on its own motion without a request. And so it would be within the commission authority to direct to do an own motion, which we could bring to the next meeting. I would need to notice it, to do an own motion to issue a commission advisory opinion to both OSU and ASOSU regarding our conclusion or determination that the Judicial Council, the Senate, etc., would all be subject to the public meetings law requirements.
Thank you, Executive. My first impression is, speaking as the chair for what this is worth, is to appreciate that suggestion. Before turning to Commissioner Burke one more time, I will make 3 comments, and I'm not sure the order that I should make these. One, I'm pleased that the quote issue, unquote, we're contending with here has been fixed by the respondents who have appeared before us today. And I appreciate the candor of their remarks before us and fluency of their words, which was impressive. Thank you. I wish that one of our prerogatives as a commission was to issue a letter of education now before moving to an investigation and then issuing one. And I've said that 10 times, and I just said it 11th, so I've said that enough times. The last thing, and I think this is where the executive's comments may be persuasive to me, is I wish my friends at Oregon State University would provide better counsel to the bodies under them, because it strikes me that in part we're here because of OSU's legal advice, which I think we're determining to be wrong. But that's a friendly comment to my friends at OSU, and they are my friends in many cases. So Ms. Reeves, take my words for what they're worth, and they may be worth nothing. Those are pre-comments from me. I'll turn to Commissioner Burke before we decide how to proceed here, moving along. Mr. Burke, please.
Very quickly, I think a letter of education is still better than an advisory opinion. An advisory opinion is an opinion. A letter of education, I think, is stronger because it is essentially an assertion that something is true rather than opining something that is true. And I think that could have a greater impact. The comment of Commissioner Thompson, I think, was well taken, is that with the turnover, who's going to remember who got a letter of education? My response to that would be that if there is a letter of education, whether it is to the institution of the board or the individual members who are sitting on that board, that is on record with us. And anyone who is in a similar situation in the future who does any research will find that. And that will be incredibly useful as a documented precedent for cases like this. Thank you.
Thank you. I think we've had a sufficient amount of discussion today on this issue. So now comes time for us to move toward a decision. And maybe the best approach, since comments have been made across the board, and I appreciate all the comments from everybody. I'm looking for a colleague willing to make a motion to see how that flies, if I can put the words that way. Looking for a motion. Commissioners Payne, Burke, and Thompson have made comments. Is one of you prepared to make a motion? Yep. Commissioner Payne, would you like to start, or?
I will. I hereby move that the commission find that there is a substantial objective basis, believing that, sorry, I lost my place on the agenda.
45.
Yes, Madison Jones may have violated ORS 192.630 subsection 1, ORS 192.630 subsection 2, ORS 192.640, and ORS 192.650, and that the commission should investigate accordingly.
Thank you, Commissioner. You've heard the motion. I see one hand. Commissioner Burke, please.
I was going to make a motion similar to that of Commissioner Payne. I would just add that the word is may have violated, that today's vote will not indicate definitively, even if we go forward, that there has been a violation.
Relative to the language of the motion, that is, in my judgment, having read that motion many times, a very proper distinction. Colleagues, questions about the motion? Comments on the motion? Commissioner Payne, are you raising your hand? Maybe I did. I thought I saw it. Thank you. Sorry. Okay, the motion before us, it pertains to item number 45 on our agenda involving Ms. Madison Jones. Hearing and seeing no further comments on the motion, the administrator will now call the roll, please.
Commissioner McCully. Aye. Commissioner Burke.
Aye.
Commissioner Thompson.
No.
Commissioner Payne.
Aye.
Chair Fiscom.
Aye.
Motion failed 4-1 with 1 abstention.
Executive, please explain to the listeners here, including respondents, what the effect of this action is in fact under our rules.
Under the statutes and rules, there are required to be 5 affirmative votes for the commission to take action or move a case to investigation. If the commission does not have 5 affirmative votes, the matter will be administratively dismissed.
I hope you all heard that. The effect of this, in light of our procedures pursuant to Oregon state law, is that unless there are 5 affirmative votes in any direction, the matter before us dies its own death. If I can use those words, and if they're better legal ones, somebody can amplify on that. But the upshot on item 45 is it has now gone away. Understand that? Anybody have a question about that procedurally? We'll now move to item 47. The same motion. Commissioner Payne, please.
I hereby move that the commission find that there is a substantial objective basis for believing that Colin John Carmichael may have violated ORS 192.630 subsection 1, ORS 192.630 subsection 2, ORS 192.640, and ORS 192.650, and that the commission should investigate accordingly.
Colleagues, you've heard the motion. You're familiar with it by now. I will ask the administrator to call the roll, please.
Commissioner McCully. Aye. Commissioner Burke.
Aye.
Commissioner Thompson.
No.
Commissioner Payne.
Aye.
Chair Fiscom.
Aye.
Motion failed 4-1 with 1 abstention.
Same commentary. Respondents, that motion has failed by a 4-1 vote. We'll move now to item number 49 on our agenda. Commissioner Payne, please.
I hereby move that the commission find that there is a substantial objective basis for believing that Anna Godfrey may have violated ORS 192.630 subsection 1, ORS 192.630 subsection 2, ORS 192.640, and ORS 192.650, and that the commission should investigate accordingly.
Colleagues, you're familiar with the motion before us now, so I will ask the administrator to please call the roll. Item 49.
Commissioner Thompson.
No.
Commissioner Payne.
Aye.
Commissioner McCully. Aye. Commissioner Burke.
Aye.
Chair Fiscom.
Aye.
Motion failed 4-1 with 1 abstention.
Same result. respondents, motion fails by a 4-1 vote. This concludes the items involving you as you've appeared before us today. Couple quick comments in no particular order. Ms. Simonette and Ms. Reeves, thank you for joining us today. Those who have appeared before us have allowed you to appear with them, and we appreciate your presence today. The three of you, Ms. Jones, Ms. Godfrey, and Mr. Carmichael, thank you again for your appearance today. Thank you for the candor and precision of your remarks. I hope this, in the spirit of comments to you, has been at least an educational experience, if not more. Thank you for your candor and thank you for your truthfulness, and move on and have a good weekend. Additionally, Merry Christmas. Thank you.
Thank you.
Thank you,
Oh,
Commissioners.
Okay, our staff will continue to move forward to get things ready, but our executive wants to say something.
Yes, we need to bring Mr.
Paola.
back in, and then we can resolve those last two and then take our break and do the other.
The question I was going to ask is when you want to take a break, because the summary you gave me said take a break at 10:55. We're already later than that. So we need to, let's just force ourselves to proceed through this. Please admit Mr. Paola again.
And Commissioner Payne has her hand up.
Oh, Commissioner Payne, please.
Yeah, Chair, is there an opportunity to make a motion for an advisory opinion?
Thank you.
For
Thank you.
OSU, and I still think that could be helpful in this situation, even
concur.
though a letter of education will not be issued.
Please make the motion. I'll be pleased to support it.
You would need to make a motion in open session.
Okay.
Okay, great.
Mr. Payne, by the way, I should say Commissioner Payne may have to leave us at 11:30 today. I wanted to say that maybe if that's what you're going to say for a previous engagement.
Yeah, I was. So if somebody else can make sure that happens, I won't be here, but if somebody else could make that motion, I would support it, and hopefully we'll have enough people to. Do you have to have 5?
Yes.
Okay.
Commissioners Thompson and Fiscom will make sure that happens in your departure.
We may have another issue.
We also need to stay within just our executive session.
We're not going to do it now. We'll do it later in public session.
Correct, but we're limited on what we can discuss in executive.
I apologize.
Right, we need to.
Forget what I just said.
I won't say my comment, but
Commissioner, thank you. Let's admit Mr. Paola, if I'm saying his name right again, back into our process. He's on. Mr. Paola, can you hear me?
Yes.
Thank you very much. Now comes the time for us to decide what to do about the matter before us. Thank you for your testimony. Anybody need a refresher course of what Mr. Paola said to us? I think the answer is no. Commissioner Payne, please.
I just have a question regarding what, Mr. Paola, as I understood it, objected to the fact that the Judicial Council was, or the concept that the Judicial Council was not subject to public meetings law in order to avoid being part of the violation. Was he required to not attend a meeting? How would he, maybe this is a question for our council, would he have been required to not attend the meeting in order to avoid a violation? Just, I might lean towards a motion to dismiss in this case.
Yeah, correct. So if they're presented with a meeting that may violate the public meetings law, you would not participate in that meeting. Sometimes during those scenarios, the person would announce that they, so it's on the record that they announce that they believe that this is not a lawful meeting, and they would then leave the meeting immediately. Those are the type of things. But yes, if they participate in the meeting, they're considered to have participated such that they're subject to a complaint or a violation.
Follow up, Commissioner Payne?
Okay. No,
thank you.
That answered my question. Thank you. I'm prepared to make a motion.
Mr. Payne, please.
Okay, I hereby move that the commission find that there is a substantial objective basis for believing that Mateo Paola may have violated ORS 1926301, ORS 1926330 subsection 2, ORS 192640, and ORS 192650, and that the commission should investigate accordingly.
Thank you. Colleagues, you've heard the motion. By now you're familiar with it. Any questions, comments? Hearing and seeing none, the administrator will call the roll on item number 48.
Commissioner Burke,
Aye.
Commissioner Thompson,
No.
Commissioner Payne,
Aye.
Commissioner McCully,
Aye.
Chair Fiscom.
Aye.
Motion failed 4-1 with 1 abstention.
Mr. Paola, thank you for your patience in coming back to us. Let me just tell you what has just now happened. The motion to proceed failed 4-1 because under Oregon state law, we are required to have 5 affirmative votes to move in any direction. We got 4 affirmative votes. The upshot of that is that the motion before us failed 4-1. That issue now, by definition, goes away. I want to thank you for bringing the issue before us and for your patience with our schedule and for the candor of your remarks. Thank you for your appearance today. Frankly, that's it. Thank you for your patience with our schedule.
Thank you.
Investigator Fenstermaker, the 2 other items we have that dealt with these similar issues would be items 46 and 50. Am I right?
Correct.
And do we have anybody appearing on those matters?
We do not.
So we can consider those in order. Item 46, do we need to have your report or does it stand as given?
It stands as given.
Thank you.
With the exception of the changes to the names.
Absolutely. Thank you for that comment. Colleagues, we're now ready for a motion on item number 46, dealing with Mr. Alexander Kerner. Commissioner Payne?
I hereby move that the commission find that there is a substantial objective basis for believing that Alexander Kerner may have violated ORS 192-630 subsection 1, ORS 192-630 subsection 2, ORS 192-640, and ORS 192-650, and that the commission should investigate accordingly.
Colleagues, you're now familiar with the motion. We'll now have the administrator call the roll. Item 46.
Commissioner McCully,
Aye.
Commissioner Burke,
Aye.
Commissioner Thompson,
No.
Commissioner Payne,
Aye.
Chair Fiscom.
Aye.
Motion failed 4-1 with 1 abstention.
Motion fails 4-1. Colleagues, we'll now turn to item 50. The investigator's report stands as given. Commissioner Payne, please, item 50.
I hereby move that the commission find that there's a substantial objective basis for believing that Jack Fraley may have violated ORS 192-630 subsection 1, ORS 192-630 subsection 2, ORS 192-640, and ORS 192-650, and that the commission should investigate accordingly.
Administrator, please call the roll. Item 50.
Commissioner Payne,
Aye.
Commissioner McCully,
Aye.
Commissioner Burke,
Aye.
Commissioner Thompson,
No.
Chair Fiscom.
Yes.
Motion failed 4-1 with 1 abstention.
Thank you. Before we take a 5-minute break or so, I want to thank our investigator for her diligence in carrying these items before us today. This has been, for me, a fascinating issue that I had no idea of predicting would occur on our agenda. I sure hope that Oregon State University will spend more time deciding what the public meetings law is. That's enough for me. We'll take a 5-minute break. The executive session will now be adjourned temporarily. We'll come back in executive session and proceed through other items on that agenda. Director, please introduce our new colleague. I forgot that earlier.
Yes, for those of you here, we have a new investigator with us, Lion Galloper. And I will say more about her background when I give my ED report.
Thank you. I wanted to mention that because if you need to meet Lyanne, please do so on the break. Thank you.